Hello and welcome to Law Deals, the podcast for legal professionals navigating the business of law, law firm partnerships, and law firm ownership transitions. I'm Ed Alexander, and today we're diving into private equity ownership of law firms, direct and indirect. This is the second episode in a multi-part series. The prior episode, we talked about direct ownership of private equity in law firms. And in this episode, we're going to talk about indirect ownership. So for this key topic, I'm joined by my friend Jonathan Hawkins, the founder and managing partner of Law Firm GC, an Atlanta-based law firm that is focused on representing law firms. All right, Jonathan, welcome to Law Deals.
Ed, glad to be here. Thanks for having me.
Good. So in the last episode, we went heavily into the direct ownership, what that looks like, where it's permissible and where it's not. And in this one, we're going to talk about what a structure that I really see more often in private equity or non-attorney ownership law firm transactions, and that is indirect ownership. And this you might have heard as the legal service organization or a management service organization. So let's talk a little bit about this. So what have you seen in these LSOs or indirect ownership arrangements?
Yeah, so I'm seeing more and more of this. But basically, for those who aren't aware, it's basically you carve out the lawyers and the legal work, and you put that over here. You silo that into the law firm, and then everything else gets put into this other entity. So operations, marketing, just the back office type stuff of a law firm all gets put over there, and then there's a services agreement between the two entities. So the back office entity, if you will, provides all the back office services to the law firm, and the law firm pays for that via the sort of services agreement. So all the legal fees get earned and all that go to the law firm, not to the other. And the way they get the money over to the non-law entity is through that services agreement.
Right. So
did I sum it up there?
That is perfect. That's exactly the structure, right? And so let's just do a quick recap on the ethical rules that we're kind of focused on here, right? So the ethical rule, ABA Model Rule 5.4, and really the two components of that are no fee sharing and no partnerships with non-lawyers for the practice of law, right? And so those are Florida Bar Rule 4-5.4 for those of you in Florida. And ultimately, right, we have a couple of things that we want to be careful about. We want to be careful about sharing legal fees, and we want to be careful about engaging in other business with non-attorneys, right? So let's kind of walk through what these look like, because there's really a bunch of components that we're stripping out of the law firm. So if you think of your law firm, you've got the attorneys who are licensed to practice law, and they're supervising the paraprofessionals and legal assistants, right? And then there's everything else, right? So you talked about a back office, invoicing, it's managing the money, it's accounting for the trusts, for trust account. It's doing the marketing, right? Anything that isn't a core legal function of representing clients or the practice of law. So Jonathan, let's talk about what constitutes the practice of law.
That's a good question. It depends on the state. I'll say that. So for example, basic example, in Georgia, doing a residential real estate closing is the practice of law. There are other states where it's not. You don't have to be a lawyer to do that. So it definitely is jurisdiction specific. And so, many states have statutes or opinions that'll say this is practice law, this is not. Again, depending on jurisdiction, you got to figure out what is or is not. But basically, providing legal services to clients, representing clients in legal matters, is what I would broadly say providing legal services.
Right. So if I were to break it down, clearly appearing in court, doing depositions, anything related to the judicial process. The transactional side's a little bit more difficult because we almost combine the consulting piece with the legal piece, right? So if you're providing legal advice, right, should somebody do this? Should they not do this? And what are the legal ramifications of it? Clearly the practice of law. But we might also delve into coaching or, financial advice or something along those lines, which the ethical opinions permit us to do aside from the practice of law, but isn't really the practice of law. Okay. So good. So now what we done is we have this private equity group that comes to you, Jonathan. You've got a practice and it says, hey, we want to do a deal with you. Right. So in my experience, that structure looks like we will pay you money and you will transfer all of the non-legal aspects of your practice to this LSO, legal service organization, that we set up. And we will enter a contract with you, a management contract, and you will pay us fees for the services provided, which can include making paralegals available to the practice, making legal assistance available to the practice, marketing the practice, and invoicing and billing. So, what are some of the ethical issues that come up in that type of relationship?
Well, the big one that really has always stood out to me is the payment for the services from the law firm to the LSO. So how do you get the money out of the law firm to the LSO? I've seen instances where they want it to be a percentage based on a percentage of the revenue to the law firm.
If I had sound effects, that would be the you missed it buzzer, right? The
yes,
right,
and that
done.
is absolutely would run afoul of every ethics opinion and legal rule out there, because that would be what they consider sharing legal fees. And so you have to set it up so it is a flat fee, or there probably are some other ways to potentially sort of get at it, but it's not based on revenue. It's based on something else.
So the key there is really there's a backdoor way to do this too, and I want to kind of get into that. But the key is the fees cannot be based on what the legal fee revenue is of the law practice, the stripped down law practice, right? The minute you do that, you're in violation of the rules. Okay. So let's talk about the backdoor. So the backdoor method, right, is I provide all these services, and the impermissible backdoor is I make those services effectively like 90% of the revenue of the practice, right? And because I'm trying to strip off profit into the LSO. And so if I do that, then the fee for the services provided is not reasonably related to the services provided, right? And so that is also a violation of the rule. Now, have you seen that as well?
I have not participated in that, but yes, people try to do these things, yes.
Just to be clear, neither have I participated in that. There's another component to this that we'll get to in a minute that is equally disturbing, right? And so what we have to do is those fees for services have to be at market rates, okay? And market rates include a profit component for the LSO. The LSO is not a not-for-profit entity, but we can't strip out every bit of profit out of the law firm piece, okay? Okay. One thing I think that I just want to add to the structural component that we didn't really talk about is that not only does the lawyer get money in that transaction, but typically the lawyer is also an equity holder of the LSO. So they participate in the LSO. So they're going to get some profit out of that LSO in addition to being paid for the transaction. And we would call that the back end, right? And so in this case, you as an owner could be incentivized to kind of jack the rates because you're participating on the backside. But it's something you've got to avoid because you will run afoul of this arrangement. Okay, so that's kind of one issue, right? The service rates have to be fee for service; they have to be structured properly. Any other items on that you can think of there?
On the fee piece?
Yeah, the fee for service.
So another issue. So it's let's just call it a flat fee per month for the services provided, and then all of a sudden the law firm blows up. So you expected 1 million in revenue, and all of a sudden it's 10 million in revenue. So then you say, oh, we're going to jack up the rates now, month 2. So that's another issue. You can change the rates, but you cannot do it too often. And so, you set the rate. I would say no more than once a year you can change it. So at the one annual, the annual renewal, you can sort of reset the rates for whatever reason. But if the flat fee is going up and down every month, depending on the revenue of the firm, that's going to get you.
Yeah, that's a problem. Right.
Yes.
Right. Yeah. So I would kind of say one other component to that, right? If you charge on a per service basis and the firm revenue goes up requiring additional services, that would be permitted. It's the rate of those services that you're specifically talking about here, right? And that's kind of a way to back into the percentage. You look at what the law firm is doing and you say, okay, well, we want 60% of the profit, so this is how we get there, right? Well, that's where you got to be careful, right? Because number one, you can't be changing that all the time. And number two, it's got to be reasonably related to the services provided. So you can come up with some numbers. What does it cost to have a paralegal? What does it cost to do the back end? Maybe the back end is a minimum plus, some dollars per invoice plus something else, as long as you price it in a meaningful manner and you don't jack those prices around all the time, I think you're probably in good shape with that structure.
And that's a great point. That is one of the ways to tie it, because in some way, if the revenue is very high or is increased in the firm, then you would expect the amount of services needed to support that additional revenue is going to go up, and those need to be paid for. So that's sort of how you get there.
Yeah. So when looking at that structure, right, you want to be sure that you understand, as the lawyer engaging in these transactions, you want to be very clear about what that management agreement looks like and how the pricing is set in that management agreement. Okay. So one other thing that I've seen in term sheet for these that have raised alarm bells, right, is the issue of what happens if the jurisdiction ultimately allows non-attorney ownership, right? And I saw one that came in where the the LSO was able to then buy the law firm for a de minimis amount of money. In that case, it was $1,000. And that's basic. So, we have this concept of de facto merger or, really it being a sale, even though it technically isn't a sale. And from that standpoint, it would seem to me at that point, you have non-attorney ownership of a law firm in that case. Would you agree with that?
So what do you mean? Because they have the right, basically the option to purchase?
Yeah, it's like a financing lease where at the end you can buy the equipment for $100, but the equipment's worth $20,000, right? It's the same kind of thing. So you've got a law firm that's worth millions of dollars, and now we're able to buy it for $10,000 or some ridiculous amount of money.
I will say this raises sort of a bigger question that I've had in my mind about these structures. Even if we structure it completely no issues, and we're pretty confident there's no issues, I'm not convinced yet that some bar regulatory body is just going to be overly aggressive and just come in and say, yeah, it technically complies with everything, but this is really an end run and we're going to shut you down and we're going to come do all this stuff and disbar you and all these things. I'm not convinced that's not going to happen. So even if you do all these structures and we set it up and we're talking about all the pitfalls, but even if you do it 100% right, I am not convinced that it is without risk, 100% without risk.
I would agree.
What are your thoughts on that?
No, I would 100% agree with that, right? And at least in Florida, we have kind of a little bit of an out because we can kind of call the Florida Bar hotline, I mentioned them last episode, and get some guidance on how to do this. And they may say, no, there's no way to do this, right? I think the issue you're really talking about, to me, is control, whether it's actual or effective control, right? And in the example I gave, right, they've got this option, so effectively they have the equity. But if you can't practice law without using the management service organization or legal service organization, how are you really independent of that legal services organization? Is that the angle that the MAR might come in and say, sorry, that's really effectively a partnership for the practice of law?
My counter to that, put on my argument hat is, well, I can't practice law without Westlaw and Lexis. I can't practice without my practice management software. I can't practice law without my internet connection. I got all these services that I use, and obviously, I could contract with VAs. I can contract with contract attorneys. There's all these relationships that small and solo firms already do. They're just not consolidated under one umbrella. That would be my counter argument. But I still, yes, if they want to come in and throw the hammer down, they're going to do it. And I imagine it would probably be like back in the day when attorney advertising was not allowed, and there were lawsuits all over, and they had to litigate that issue to open the door. That's probably where this is headed eventually, but maybe not. Maybe not. Yeah. I don't know.
So my counter to your argument, Jonathan, would be that those are true arm's length relationships. And the question is whether an LSO is or is not an arm's length relationship, right? And I don't think it is, because you've got some level of common ownership and you've got this ongoing relationship. And especially if the LSO was only supporting one law firm, right?
That was going to be my question. What if the LSU, LSO, you've got a lot of these private equity groups that are rolling up multiple firms. So they have the same LSO that's servicing many law firms. Does your opinion change there?
I think it makes it a little bit better for purposes of making the argument. I can't predict whether the bar would say that's acceptable or not, given that the Board of Governors unanimously voted down non-attorney ownership of law firms in Florida, at least. I'm going to say they would say no to pretty much this structure at all, but that's just a prediction. So no promises.
So let me throw something out here. I want to get your opinion. So this is something that I've been saying for a few years now, privately and to people. I have this theory that, and it's, we've got this boomer generation that has basically dominated everything their entire life. And they bend the rules to favor them. And so we are getting to the stage where you got all these older lawyers, and we do this, sort of transition planning, and it's not easy to get out of a law firm. It can be done, but it's not easy. And traditionally the options for senior lawyers that have a practice or a firm, if they can't sell it, they go merge. They basically go to another firm. That's been the only option. And you can get paid, but maybe it's not a big lump sum payment. Now that private equity is knocking on the door, there is now an option where someone can write a big check. And you've got all these older lawyers that there are probably more of them than are younger lawyers. Right. And they're going to say, hey, this is our exit liquidity. Right. This is our exit plan. Let's change the rules now. So there was no. And they're like, they look around and they say, all right, it's time to say yes. I don't know. What do you think of that?
I think that is an excellent point, because the reality is, and I've always felt like the rules were there to protect the larger firms and the firms that were really run by the boomers. So I would agree, right? Because you saw this big change in the rules after the 1970s as the boomers started getting a little bit older and what was changing. So I think that's a good theory. I like that theory. But the one thing I would say about the equity transactions, or at least giving them some liquidity to get out, is that's one of the promises that private equity is putting into these legal service organizations, is that they're setting it up so that they will finance the buyout for the attorney, right? So you'll get some money. You can take some money off the table day one. But then when it comes time for somebody to move up in the organization, then obviously, at that point, they'll help fund that arrangement, which has always been traditionally been a problematic arrangement, right? Because associates have no money to put into the deal. And so we've kind of had to work around it, and it takes years when you're working around it. You've got to be really planning far ahead. So,
another bigger picture element here, medical practices have been doing this for years. Accounting practices, accounting firms are behind the medical practices, in my view at least, but they're there now. They're selling out to private equity, and the law is sort of the last
holdout.
Big professional service industry that's headed there. I'd be curious, and I've not done this really on any vast basis, but I'd be curious to hear what the accountants are saying about their recent private equity exits, both the partners that got the good exit, the ones right behind them, and then the ones behind them. What do they think about it? Was the promise fulfilled? Is it going to ruin the legal industry like some say it's done in the medical? I don't know. Do you have any thoughts on that?
So there is a podcast that I listened to called The Soul of Enterprise, and they had a guest on who'd gone through a private equity transaction. It was a fascinating episode. That guest was one of the senior partners and was extremely happy, obviously, because he got a check. I unfortunately did not hear from any of the junior partners about what it would look like. My take is, if you look at what other investment transactions look like, that the world would change for them from what it was, because you go from a professional bias into a business bias. And I don't think all professionals are going to be able to make that transition equally. Some will certainly do that. Others, it will chafe, right? And they'll have some problems with it. I would be interested to see what the younger accountants look like, right? Would we be moving into more of a, big accounting firm and the way that they are alleged to have grind through their new people? Or is this, more in the nature of, we want to keep our people, we set up the right culture, all of that? Good questions. I don't know the answers to them.
So in the law, at least, and I know you've seen this a lot in your practice, when a senior partner or senior partners are trying to sell to the next generation internally, there's often a lot of pushback. And the younger lawyers, they're risk averse, they don't have any money, and they're like, why do I even want to buy this? So like for a lot of younger lawyers, not all, but a lot of them, they just want it. They want to do their job and get paid well. So they don't even really care about owning or anything like that. So maybe from a large, population of the younger lawyers, maybe they just don't even care. I don't know.
Right. I mean, on some level, I think it gives you a better pool of talent, right? Because if the LSO is servicing multiple law firms, they're going to see talent, and talent that is interested in being an owner or management, that type of thing, versus that talent that you're talking about there. So from that perspective, an LSO would be a wonderful thing if I'm a senior attorney and I'm looking for a successor, right? I just have to pick from who's in my firm. Now I can go to the LSO and say, hey, do you have any candidates? Let's bring them over and let's get them started on, being the manager of this firm and participating in the LSO. The other piece is it opens up this whole issue of stock options and equity ownership for lawyers in the LSO. And, from that perspective, they're going to participate early on. We get some golden handcuffs. There's some benefits to that arrangement. Yeah.
Great point. And real quick, in the LSO, you could give options and equity to the non-lawyers at your firm. That's something I've always had a problem with as well. I should be able to incentivize my receptionist up to a partner with equity rights, options, whatever, profits, interest, however you want to structure it, in my law firm internally. Now you can share profits, but you can't really, in most states at least, give sort of the ability to get a capital gain type.
Mm-hmm. Right. Yeah, I think, Jonathan, the issue there, think about the family law firm that has a psychologist on staff, right? How can you retain that person? How can you incentivize them to stay with the firm, right? And we do it too. We've got consultants that we work with, right? Now they're not on staff, but would I bring somebody on staff and be able to do that? I might be able to do that. That really is one really good element to the LSO arrangement. I'd be interested to see, you were talking about private equity groups of lawyers in the last episode, right? What about private equity groups of lawyers that are combining practices? So they're doing an LSO, right? We've got somebody who really is a business manager, and now we're putting together these practices under the LSO. Obviously, we have to figure out what are the conflict of interest issues that potentially come up, what are the client confidentiality issues that come up, and how do we deal with them. But in that structure now, I now can participate as an indirect owner of a PI firm, an indirect owner of a family law firm, an indirect owner of a estate planning firm, and maybe multiple estate planning firms in different locations. So the LSO, if we got out of the context of private equity, might offer some really interesting investment opportunities for lawyers generally.
I agree. I'm fascinated with it. At least from my perspective, I know there are a lot of strong feelings on both sides. Some that are just, we need to open it up completely. And then there's others that, oh my God, we can never do this. It'll be the death of the professionalism, blah, blah, blah. I'm really not on either extreme. If I'd lean more towards, hey, let's open it up. That's probably where I would lean. But I get it. I get all the arguments, but it is fascinating to me.
Okay.
Partly because it's what I do. But
yeah, it is fascinating. It is really fascinating. And, ultimately, just to wrap that piece up, the management and services agreement is really the key, right? And so it's, what does that look like? What does it make available? How many firms are under the LSO? How are conflicts handled? How's confidential information handled? So this has to be a significant and detailed agreement to make sure that it complies with the rules. Now, you gave a preview about our next episode, which is going to be, okay, I'm sitting here, right? All this is going on around me. What, as the small law firm owner, right? Couple mil a year in revenue. What do I do in this environment? Do I have to make changes? Do I stay the same? Do I reach out to private equity? So we'll get into that on our next episode. Jonathan, thanks for joining me. This was a great conversation. I really appreciate it.